Today's case is one you won't forget. People versus Molly Fox. On paper, it looks straightforward, a defendant battling substance abuse while under court supervision. But as we peel back the layers, you'll see why the courtroom was anything but calm. This isn't her first positive test. In fact, it's her third violation for cocaine, and the judge isn't buying the excuses. We'll hear about friendships gone wrong, failed recovery attempts, and a mother of 3 facing the possibility of losing her freedom. Will the court believe she's ready to change? Or is this just another round in a cycle she can't escape? Stay tuned, because the judge's patience is wearing thin, and the tension in this room is about to explode.
Have you seen it, counsel?
Yes, Your Honor, I have seen it.
She's positive for cocaine.
Right. Your Honor, when the bond was set, I wasn't actually present when the bond was set, but at that point, I think they all agreed that her major problem was that alcohol. That was why she entered a recovery program through community corrections. And she's also been attending AA. Now, she's not been positive for, as I understand it, she's not been positive for alcohol use since that time. This cocaine use is kind of, I don't know, an anomaly. And it seems from my discussion with my client, it's kind of situational, and she realizes that this is absolutely unacceptable.
She had another anomaly back in March.
Right, I understand. But
This is where the courtroom temperature starts to rise. The defense paints this as a situational slip, an anomaly caused by a toxic friendship. But the prosecution? They've heard it all before. This is violation number 3. And when the judge cuts into question just how many wake-up calls it takes for someone to stop using cocaine, you can feel the frustration. Here's the key legal takeaway. Courts tend to treat repeated violations as willful noncompliance, not accidents. Each failed test stacks against her, making it harder for the judge to justify leniency. What do you think? Is this truly a slip or a clear pattern of disregard for the court's orders?
got into cocaine use, and she would sometimes participate when she was with that person. She realizes she has to break off all contact with this friend because it's apparently evolved into a relationship in which cocaine is customarily used. So we would ask, of course, that bond be continued, and if the court thought it was appropriate, she could be put on a tether. She has been going to, she had 8 weeks of first phase recovery program, and she'd started the second phase prior to this cocaine use. And she also has been going to AA once a week in addition. So the recovery program, I guess I would have to say, has been partially successful. And we would like to have an opportunity for her to continue to work on her recovery through that. And I know Mr. Kennedy and I have talked about possibility of resolving the case through recovery court, but he's not sure that she's eligible. And I've been waiting to find out if that's true, because that might very well be a good resolution. So, and in the meantime, I mean, she is the caregiver for three minor children, ages 13, 10, and 5. They're all her children. And her significant other with whom she lives, he works full time for one of the car companies, I forget which, for Ford, and is gone in the daytime. So caring for the children, especially when school gets out, which will be pretty soon now, would be very difficult without her presence. But so of course, we're asking for bond to be continued or possibly been modified to have provide for her to have an alcohol drug tether.
Now we hit one of the most telling moments, the suggestion of an alcohol and drug tether. Essentially, it's an ankle monitor that detects substance use. Sounds like a solid fix, right? Not exactly. The judge points out a major flaw. The tether can't even detect cocaine. This reveals a bigger truth about courtroom negotiations. sometimes defense proposals sound like solutions but don't address the core problem. It's a classic standoff. The defense argues she's making progress. The judge questions whether that progress is real. And let's be honest, if the technology can't detect the drug in question, is it really a safeguard?
Of course, well, community corrections made
This
it
is a
possible for her.
third violation with cocaine.
I'm sorry,
This is her third violation with cocaine.
apparently so.
Yeah, that's a problem.
It is a problem, and but I think a tether would definitely take care of that problem.
I don't have a tether that reads cocaine.
Well, that's what I wasn't sure when she suggested it, whether that was feasible. She seemed to think it was, but I don't know.
She who?
My client.
Of course. She's going to tell you that, and then she's going to go out and use cocaine.
Well, maybe she just doesn't know. I didn't know.
She does what drug addicts do, and they tell you something that's not true.
Well, I don't know that she's truly an addict because her use has not been that frequent. But at any rate, I totally agree with the court that she can't be using cocaine, and I think she also agrees, and she
At
understands.
what point did that dawn on her?
I'm sorry?
At what point did that dawn on her? When we ordered that she couldn't use illegal drugs? In January when she tested positive? In March when she tested positive? Or this time when she tested positive? Which point did she all of a sudden figure out she can't use it?
Well, she should have figured it out beforehand, Your Honor, but she now tells me she has figured it out, I guess you could say.
I always hate asking, but I'll ask. Why not? I'll bite. What this time made her figure it out?
This is the moment where the defense leans hard on the human side. A mother of 3, caring for her kids while her partner works long hours. They hope the emotional weight will sway the court. But remember, judges balance compassion with public safety. Prior violations, failed recovery efforts, and repeated exposure to drug environments don't exactly inspire confidence. In legal terms, ongoing noncompliance puts the court in a position where revoking bond becomes not just possible, but probable. And yet, you have to wonder, can someone truly turn things around when they cut ties with the people feeding the problem? Or is that just another promise waiting to be broken?
I hope that she has come to the realization of how damaging to herself that this is.
I'm going to adjourn the probable cause conference in this case to June 5th, 2025, 9 a.m. Because of her violation, defendant's bond is revoked, defendant is remanded.
Thank you, Your Honor.
And there it is, the gavel drops on Molly Fox's bond. Revoked. The court sets a new date, and until then, her freedom is on pause. This case is a textbook example of how repeat violations erode a judge's willingness to believe in rehabilitation without stronger safeguards. The takeaway? In the eyes of the law, every test matters. Every violation counts, and personal struggles don't erase repeated breaches of trust. If you found this case as shocking as we did, hit that like button, drop your thoughts in the comments. Do you think the judge made the right call? And don't forget to subscribe for more jaw-dropping courtroom breakdowns.